of Wake County File Number 18 CVS 15292, Holmes and others versus Moore and others. And we're continuing here the third day. Before we resume the testimony of Ms. Fairs, are there matters that need to be taken up prior to?
Nothing from plaintiffs, Your Honor.
And nothing from the legislative defendants, Your Honor.
And nothing from the state defendants. Thank you.
All right, Ms. Klein, are you ready to proceed with Ms. Fairs?
I am, Your Honor. Good morning.
Good morning. All right. Then, Ms. Beal, has Ms. Fairs been allowed into the virtual courtroom just yet?
She has.
Okay, Ms. Fairs, can you hear me this morning?
Yes, I can.
Okay, great. Ms. Klein, you may proceed with your direct examination of Ms. Fairs.
Thank you, Your Honor, and may it please the court. Good morning, Ms. Fairs. Do you understand that you are still testifying under oath in this matter?
I do.
Ms. Fairs, are you familiar with House Bill 1092?
Yes, I am.
Can you describe that bill?
That was the bill enacted in the 2018 short session that proposed the constitutional amendment to require photo ID for voter identification.
Is it normal practice for the General Assembly to propose and enact a constitutional amendment during a short session?
No, it is not the normal practice. There's an exhibit that, and it's exhibit number 6, that shows when all of the constitutional amendments proposed since 1971 have been enacted. And if you look at that exhibit, you can see that on the left column, it indicates the session law in which the act was enacted. And in all but 3 of those instances, the constitutional amendment was enacted in the long session. And that makes sense because constitutional amendments you would imagine would require deliberation and some time for consideration.
For the record, I'd like to pull up the Fairs Report Exhibit 6. This is JX31 at PDF page 94. Ms. Fairs, you testified about the first column on the left. Can you describe to the court what that first column on the left is showing?
The first column shows the session law it was enacted, and the year that it starts is the session. And you can see that their odd-numbered years would be the long sessions.
And if we scroll to the next page, this is PDF page 95.
You can see the same practice continues. All of the session laws have odd-numbered years.
And if we continue to the next page, that's PDF page 96.
That holds true for that.
And the next page, PDF page 97.
Yes, it holds true for that.
And the next page, PDF page 98.
Yes.
And the next page, PDF page 99.
This page shows 2 of the exceptions. And you can see there 2004, that was a short session, and it amended the magistrate's term. That made a simple change to say that the first year of the magistrate's term was 2 years, and after that they were 4-year terms. And then in 2010 was another simple change that simply prohibited someone who was a felon from holding office as sheriff. So those are 2 of the ones, and this table was compiled by the North Carolina Legislative Library. This is a chart taken from the legislative statistics that are maintained at the General Assembly. The third exception I would mention here is one that is actually not noted in this chart. it was enacted in 1974 in response to a prior act of the General Assembly being held unconstitutional. So that was an unusual circumstance.
So this table shows how many times constitutional amendments were proposed and enacted during short sessions in total?
It shows yes. Well,
And-
let me, with that caveat that the entry for the 1974 reversal of a North Carolina Supreme Court decision holding some industrial facility bonds unconstitutional is not reflected in the chart. So with that exception, yes, that is true. You can glean from this chart that constitutional amendments are generally enacted in long sessions up until when you see 2018. I'm talking about before the 2018 session.
And can you describe for the court what happened in 2018?
In 2018, in the 2018 short session, 6 constitutional amendments were proposed and enacted in the waning days of the session. One of those constitutional amendments was the constitutional amendment for photo ID.
And was it a standard legislative practice for the General Assembly to enact 6 constitutional amendments during a short session?
No, that's an unusual amount. You can tell by the number of amendments proposed for various sessions based on the legislative statistics chart here that was definitely more than are typically proposed for any year.
Thank you. In your report, Ms. Ferris, have you come to any other opinions about the timing of House Bill 1092 beyond just the session in which it was proposed?
It was, well, based on the fact that it was enacted in the short session, it was considered for less time than constitutional amendments are generally considered at the legislature. And also it left less time between ratification and the election in which the voters could become familiar with the proposed constitutional amendment and its import.
I'd like to talk about those 2 opinions in turn. And I'll start with the last one you mentioned about the time that voters had to consider the amendment. What's the basis for your opinion that that did not follow a standard practice?
I compiled a table of all of the constitutional amendments and set out on that the date that they were ratified and the date that the election was held, and calculated the length of time between those 2 dates to determine what the average time was. And that tabulation is set out in Exhibit 7 of my report.
And for the record, I'd like to publish to the court and to the witness JX31 at PDF page 102. Ms. Ferris, is this the table you were referencing just then?
Yes, it is.
And can you briefly describe to the court the columns that are shown in this table and the information conveyed in this table?
Yes, I used the chart compiled by the Legislative Library as the base. And so the session and the amendment are taken directly, and the session laws are taken directly from that chart. They're abbreviated so that the chart is not quite as long. After that, I added the date ratified, the date of the referendum, and then a simple calculation of how many days in between there were. Typically, you'll see that when a proposed amendment is enacted in the long session, then the vote occurs not that same year, but the following year. So right before at the general election in that following year. So, and many times you have more than a year for consideration of the proposed constitutional amendment. And so that's what this is a chart that sets out those facts.
And if we scroll to the next page, PDF page 103, can you describe the meaning of the average days and the average in months?
Right,
Right.
that is simply the arithmetic average of the total days shown in the days between ratification and vote. And then just to try to put that in thinking in terms of months, then that number of days is converted into months for maybe a quicker understanding.
And what was the average?
The average here is 337 days with when that is about 11.2 months.
And does this chart anywhere show the amount of time between the date ratified and the date the voters had to decide on the referendum for House Bill 1092?
It does because if you look in 2017-18 there, the last entry required photo ID to vote. If you come across there, it'll have the number, which is 130. So about a third.
When you say about a third, what do you mean by that?
1/3 of the average 337.
Why would it be a standard legislative practice to give voters more time between the ratification and of a proposed constitutional amendment and when it's sent to the voters?
It simply gives the voters more time to understand the amendment, and it gives the groups for and against the amendment time to explain the reasoning for why a person should either vote for it or vote against it.
And is it fair to say, based on what you've testified about the timing for House Bill 1092, that the voters had less time than is standard to
Yes,
consider House Bill 1092?
yes, based on this chart, they did.
Ms. Ferris, did you come to any opinion in your report about the time the General Assembly itself took to consider whether to enact House Bill 1092?
Yes, I did. I concluded that that time was less than typical as well. In Exhibit 8 of my report, it does a similar calculation of days, but instead uses the time between introduction and enactment to determine the number of days that the proposed constitutional amendment was under consideration at the General Assembly.
I'd like to direct your attention to JX31 at PDF page 105. Ms. Ferris, is this the exhibit you were referencing just then?
Yes, it is.
Could you please explain to the court this exhibit, and particularly which column indicates the information you were talking about?
Yes, this chart uses the same format as the previous one and has slightly different information. It includes the original bill number of the bill in which the amendment was proposed. So you can use that the date of introduction of that bill to establish the date it was introduced. And then from that date, you include the date that it was ratified, which would have been on the prior chart. And again, the final column is a calculation of the number of days that elapsed between introduction and ratification.
And if we scroll to the next page, PDF page 106, here you've put average days. Just to clarify from yesterday, is this the chart in which you had some minor corrections yesterday?
Yes, it is. This is the chart in which corrections were made for the entries for 2003-4 on school fines and forfeitures and amend to magistrate's term. And as without those corrections, it's showing average days of 132, but with those corrections, I think the average goes up to about 143 or so. I don't remember the exact number.
And just to be clear, I know we covered this yesterday, but it was yesterday. Did those minor corrections change any of the opinions you reached in your report?
No, it did not.
Does this chart anywhere show the amount of time the legislature took to consider House Bill 1092?
Yes, it does. Again, if you look on the left column down to session 2017-18, the last entry is for require photo ID to vote. And if you come across on that line, it shows 22 days.
And that's 22 days compared to an average of what?
Of about 140.
Thank you. We can take this exhibit down for now. Ms. Ferris, do you remember if House Bill 1092 required implementing legislation?
It does. The text of the amendment proposed required the General Assembly to enact laws prescribing the requirements for photo ID.
So was it known when the legislature was considering House Bill 1092 that the legislature would then have to implement further legislation if it in fact was passed and approved by the voters?
Yes, it was known because that's what the words of the proposed amendment require.
Did the implementing legislation for House Bill 1092 to require voter ID, did that accompany the proposal for House Bill 1092, the constitutional amendment itself?
No, it did not.
Is that a standard practice for the General Assembly?
No, it is not standard practice. It's atypical for bills that either require implementing legislation or simply authorize implementing legislation. It's typical for the General Assembly to enact implementing legislation either in the same bill or in the same session as a proposed constitutional amendment to provide information on how the General Assembly intends to enact that amendment.
When was the implementing legislation for House Bill 1092 introduced?
It was introduced in the reconvened regular lame duck session. That happened after the November election. It was not introduced in the short session in which the proposed constitutional amendment was introduced and enacted.
Was there any opportunity for the General Assembly to consider the implementing legislation before the November 2018 election?
Yes, there were numerous opportunities. First, let's remember that the proposed constitutional amendment itself was unnecessary. The General Assembly could enact photo ID without having a constitutional amendment, and in fact had done so twice before. So at any time during the 2017 session, the General Assembly could have enacted legislation requiring photo ID, and that would have been the implementing legislation for the unnecessary amendment. But after taking that into consideration, once the proposed constitutional amendment was adopted, they could have enacted the implementing legislation in the short session, which they did not. They could have taken this matter under consideration in the standing joint election oversight committee. That committee is created by statute, and its purpose is to consider the election laws of the state. That committee did not meet between the short session and the election. The General Assembly held 3 extra sessions between the short session and the election. One of those was by its resolution to address election law topics. So they could have done it in the 2017 session, regardless of whether they proposed an amendment. They could have done it in the 2018 short session. They could have done it in one of their extra sessions, and they could have signaled the text of the implementation through the joint legislative election oversight committee. None of those opportunities were taken advantage of.
Do you recall if the ballot question presented to voters identified that the General Assembly would have to enact implementing legislation for this constitutional amendment?
I do recall the ballot amendment did not indicate the essential role of the General Assembly to implement that proposed change.
Is it a standard practice for the legislature to not include that information?
No, it is not. In times before, when the amendment itself absolutely required action by the legislature, the ballot amendment indicated that action by the General Assembly was integral.
I'd like to pull up your report JX 31 again and direct your attention to PDF page 27 of that report. And just to be clear for the record, this is marked as page 24 of her report, but is PDF page 27 of the stamped exhibit JX 31. If we could zoom in on that chart. Ms. Ferris, can you describe what we're seeing in this chart on page 27?
Yes, what we're seeing is a comparison of prior proposed amendments whose text requires the General Assembly to take further action. For example, in the first change, the second column indicates whether there was implementing law in the same session, which, as I've said before, was typical, which there were in these. The first two are before the 2018 voter ID amendment, and the amendment text in the first instance says that the General Assembly shall provide, and the ballot question for that says, the ballot question, these are the words that actually appear for the voter when the voter is in the voting booth. The ballot question is to require the General Assembly to set age limits. The General Assembly had done so in that implementing legislation, and the age was set at 72. So the second example, the amendment text is that the General Assembly shall prescribe a procedure for removal of a justice or judge. And the ballot question, which are not the whole proposed amendment text, the ballot question in the second one, again, indicates the key role of the General Assembly by saying authorizing the General Assembly to prescribe procedures. And the example of the proposed voter ID amendment, the amendment text itself is that the General Assembly shall enact general laws, but you can see that the ballot question does not mention the General Assembly. It simply says to require voters to provide photo identification.
Is there any indication in that ballot question for House Bill 1092 that the General Assembly will, for example, enact implementing legislation to decide what kinds of photo identification would be acceptable?
Nothing on the ballot question indicates that.
So when did the legislator take up the task of implementing the new constitutional amendment?
The day after, well, the Monday after Thanksgiving, the Joint Election Oversight Committee met, and a bill was presented at that committee that implemented photo ID.
And do you remember if that bill was filed and what it was called when it was filed?
The bill was filed the next day. So the Election Oversight Committee met on Monday. On the next day, the reconvened regular lame duck session began on Tuesday, and a bill was filed and introduced that day as Senate Bill 824. And I don't know, I can't say if everything was word for word the same in what that committee had adopted in Senate Bill 824.
You testified earlier that there was a resolution that convened this lame duck regular session. Can you describe the process by which that resolution came to pass?
Yes, a resolution. Let me back up just for a second to be sure that what was said yesterday about resolutions is still in mind. Once a long session starts on the date set by statute, after that, every time that regular session stops and then starts at a later date, the General Assembly enacts a resolution telling what the date is and other features of that next session. So the resolution that was adopted in the short session for the lame duck session was adopted in disregard of the existing resolution, adjournment resolution for that session. And it was also adopted the day after the United States Supreme Court had issued its order issuing the final details on how the districts needed to be redrawn for the election in November.
I'd like to pull up a joint exhibit, JX 431. Ms. Ferris, do you recognize this document?
I do. It's the adjournment resolution for the short session.
And you mentioned
One of them.
Thank you. You mentioned the date that this resolution was adopted. Does it show anywhere on this document what date this resolution was adopted?
Yes, in the last sentence, it says, in the General Assembly, read 3 times and ratified this the 29th day of June.
And you testified that that day was one day after a decision impacting the districts. Do you remember the name of that decision?
Yes, it was Covington.
And what was the effect of that decision?
The effect of that decision was to determine how districts were to be redrawn for use in the election in November. The year before, the districts had been held to be, many of them had been held to be unconstitutional on the basis of racial gerrymandering. And that federal decision had been appealed to the United States Supreme Court. And it was that day that the final details of that were, that on the 28th was the day the final order from the United States Supreme Court was issued.
So do you have an understanding of why this resolution would have been enacted by the General Assembly the day after the Covington decision?
The resolution allows the General Assembly to come back in session after the 2018 election to enact or consider any legislation it chooses.
Does anywhere on this document show what kind of session this resolution calls for?
It does. It's going to be a regular reconvene session because in section 1, it says when they adjourn that day, they stand adjourned to reconvene. So this is a continuation of the session that was started the last year during the long session. If it were an extra session, the slate is wiped clean and everything starts over. And section 2 says that when that session reconvenes, that the restrictions that are in a prior resolution don't apply, and the filing deadlines and the permanent rules don't apply either. So the restrictions that are mentioned are restrictions on the kinds of topics that can be considered during the session.
Is that a standard practice to have no restrictions on the type of topics that could be considered when the legislature has adjourned the short session?
No, no, it's not. This is the first time in history that an adjournment resolution for a regular session has never set limits on what can be considered during the next session. If yesterday, you'll recall, we talked about a regular session being a funnel and that the reconvene sessions outside of the long and the short session are very narrow. The resolutions specify a short list of topics that can be considered. This is completely in contradiction to those. There's an exhibit in my report, it's Exhibit 4, that has a list of all the adjournment resolutions for every regular session. And it indicates whether or not the resolution limited the topics to be considered.
I'd like to bring up that exhibit. This is the Fairs Report Exhibit JX31 at PDF page 75. Ms. Fairs, is this the exhibit you were referring to?
Yes, it is. And the exhibit on the left, it simply lists all of those sessions, the reconvened regular sessions. The next column sets out the resolution that authorized the session. And the final column is what we are now discussing, and that is whether that resolution limited the matters that could be considered. And you will notice that for every entry other than the November 27, 2018 regular session, the answer is yes, it did limit it. But the answer for that session is no.
And on that chart, is there any other reconvene regular session other than that 2018 reconvene regular session for which there was no limit on the matters that could be considered?
No, there are none. It was unprecedented.
And briefly, you mentioned that there were actually two resolutions of adjournment with respect to the November 2018 session. Could you briefly describe what the other resolution you were referring to was?
Yes, when the General Assembly adjourned the long session in 2017, it adopted an adjournment resolution that set various dates for the General Assembly to reconvene throughout 2017 and 2018 before the short session. And in that resolution, it required the short session in 2018 to be adjourned permanently, sine die, meaning without a date set for coming back. So by the resolution that had been adopted, the typical adjournment resolution adopted at the end of the 2017 long session, when the legislature came back in 2018, the short session was to be adjourned sine die, without coming back. And that resolution was never amended in the 2018 short session. That resolution was, in effect, it was never amended, and a new one was introduced and ratified in the last days of the short session that contradicted the prior resolution. And that resolution, the legislature had reconvened in regular sessions 4 times, at least between the long session and the short session. They had amended that resolution every time to change dates and to specify a difference in topics. But in the short session, it was just disregarded.
And was that a standard legislative practice to disregard the prior resolution?
No,
What would you have expected following standard practices to have happened?
the standard practice would have been to amend the resolution that required adjournment sine die to cross out sine die or put sine die or a date or fill in a date. It would have been amended to fill in the date that they wanted to come back.
Thank you. We can take this exhibit down. So you mentioned the implementing legislation for the constitutional amendment was introduced as Senate Bill 824. Did you come to an opinion about whether the legislature's consideration of Senate Bill 824 followed standard legislative practices?
I did. I concluded that it did not follow standard legislative practices.
And what was the basis for your opinion?
It was enacted in much less time than bills considering implementing legislation.
I'd like if I could ask the court's permission to publish a demonstrative PDX3.
Has that been introduced into evidence?
I don't believe it has, Your Honor. It has been disclosed to the defendant.
All right. Are there any objections to publishing that?
No, Your Honor, from legislative defendants.
All
No,
right.
Your Honor.
Yes, you may publish it.
Thank you, Your Honor. Ms. Fairs, have you seen this demonstrative before?
I have.
And have you had the chance to confirm whether it accurately represents your understanding of the House and Senate consideration of Senate Bill 824?
I have, and it does.
And using this demonstrative, could you please walk the court through the legislative process for Senate Bill 824?
Yes, this shows, first of all, it shows the beginning and end dates of the November session. It started on the 27th of November and ended on December 27th. On day one of the session, on the 27th, Senate Bill 824 was introduced in the Senate. It was filed in the Senate that day. It was introduced that day. It was referred to the Senate Select Committee on Elections that day. That committee met that day. The bill was given a favorable report by that committee, and the Senate referred it to Senate Rules Committee. That happened on the first day. On the second day, the Senate Rules Committee gave the bill a favorable report. The bill was reported to the floor of the Senate. It was put on the calendar for immediate consideration. Debate was had on second reading. Various amendments were adopted, tabled, considered, and an objection was made to having the third reading that same day. So the bill remained on the Senate calendar for the next day. On the 29th, the Senate voted on the bill on its third reading and sent it to the House by special message. The House referred the bill to the House Elections and Ethics Law Committee. So those are the first 3 days. Now, starting with the next legislative day, on Monday, the House Elections and Ethics Law Committee met about, I think it was 5:30 that day. They discussed the bill, but did not vote on it. On the next day, the House Elections Committee met on the bill, considered the bill, reported a proposed committee substitute, meaning a bill with changes. The committee reported the proposed committee substitute favorably. The bill was re-referred to the House Rules Committee. The House Rules Committee met that same day and adopted a different proposed committee substitute for the bill. So on the same day in the House, you have two different versions of the bill. The House Rules Committee reported it back to the chamber, and the bill was placed on the calendar for the next legislative day. So on the 5th, on Wednesday, the House considers Senate Bill 824 on both second and third readings and sends it back to the Senate for concurrence. Because the House had made changes, the House had to go back to the Senate to determine if the Senate agreed with the changes. So by special message, the bill goes back to the Senate, and the Senate receives it, puts the issue of concurrence on the calendar for that Thursday, and on that Thursday, the Senate concurs and the bill is ratified. So this is a very compressed schedule, and practically every step along the way required the suspension of the rules.
What do you mean by a suspension of the rules?
Well, as Professor Farrell explained in his explanation about extra sessions, normally the House and Senate rules are designed to slow down the consideration of legislation to make it a more deliberative process. Normally, I'll give you a few examples. So normally a bill is filed one day and under the rules, it's introduced the next day. So that once a bill is filed, it is made public and the public has an opportunity to see the bill, and then the next day it's introduced, meaning it appears on the calendar of the chamber. And that day it's referred to a committee, and the committee meets at a later time. The committee doesn't meet that same day. It's very unusual for a bill to be introduced, referred to committee. The committee meets all on the same day. And then normally when a committee substitute is reported, it's not on the calendar for that day, it's on the calendar for a succeeding day. So those are the kinds of rules that I have in mind.
Why would it be a standard practice for there to be more time, for example, between when a bill was considered in committee and when it was referred back to the floor?
The rationale for that is that it gives time to understand the changes that were made in the committee, if there are any, and just simply more time to consider the bill.
So can this deviation as to the timing that you've discussed, can that be explained by the fact that Senate Bill 824 was implementing a constitutional amendment that had just been approved by the voters in that November 2018 election?
Well, let's keep in mind that this could have been done in either the 2017 session or the 2018 session. So, and also the General Assembly enacted other amendments that were proposed constitutional amendments that were adopted that required legislative implementation, but that implementing legislation was neither introduced nor considered during the lame duck session. Marcy's Law, for example, that provided victims' rights required implementing legislation, but that legislation was not taken up in the lame duck session.
And just
So
to
if there was
clarify,
a concern about timing, then there had been plenty of other opportunities to address that concern.
and just to clarify, when was Marcy's Law voted on by the voters?
It was voted on in the same general election as the photo voter ID. And I would like to add here that in looking at the time under consideration, I looked at the time that the two prior bills that had been introduced and enacted that required photo ID had been considered by the legislature. And the legislature enacted legislation both in 2011 and 2013 to implement voter ID, and those followed what are typical patterns. Both of those were introduced in April or so of long sessions and were considered for 3 or 4 months before they were enacted. So the past examples of the legislature implementing what turned out to be what is the equivalent of the implementing legislation, they had taken a lot more time the last 2 times they did it.
Thank you, Ms. Ferris. We can take this demonstrative down. Ms. Ferris, have you read the Fourth Circuit's decision reversing the preliminary injunction against Senate Bill 824 that was issued December of last year?
I did.
Do you remember what the Fourth Circuit said, if anything, about the sequence of events leading to the enactment of Senate Bill 824?
I don't remember the exact wording, but the gist that I got was that it said there was nothing unusual about the process.
Does anything in that decision change the opinions you reached in your report in this matter?
No, it does not. There was no indication in that decision of the factors that were considered to make that statement, and there's no indication that there was any consideration of the information that I have raised in my report.
Are you familiar with the reports submitted by legislative defendants from Professor Callanan in this matter?
Yes, I am.
Are you familiar with Professor Callanan's report dated January 20th, 2021?
Yes.
And for the record, that is a joint exhibit 813. Are you aware of Professor Callanan's critique that your opinion does not account for the norms of other state legislatures or of the United States Congress?
Yes.
Do you have any response to that critique?
Yes, I think the critique misses its mark. The issue I was asked to address is whether the enactment of Senate Bill 824 followed the norms of the North Carolina General Assembly. Whatever other states or Congress has to say about their own procedures does not affect what the North Carolina norms are.
In your work advising the General Assembly in 20 plus years on procedural issues, would you typically look at the practices of other states or of the US Congress in conducting your research?
Not unless I was specifically asked to.
Are you aware of Professor Callanan's critique that your opinion in this matter would mean that the only way for the General Assembly to have escaped atypical behavior would have been to ignore the impending shift in power and wait until the long session of 2019?
Yes.
Do you have a response to that critique?
Yes, my response is that the action that was taken in that unprecedented session could have been taken in the long session or the short session. If it is an emergency, it was a self-created emergency.
So in your opinion, were there any steps the legislature could have taken in enacting Senate Bill 824 that would have followed their standard norms and procedures?
Yes, they could have done it in the long session, or at the very least in the short session.
Thank you. I have no further questions for this witness. I'll tender the witness at this time.
Thank you. Is it Mr. Patterson that's going to cross-examine Ms. Ferris for the legislative defendants?
Yes, that's correct, Your Honor.
All right, you may proceed, sir.
Okay, thank you. Good morning, Ms. Ferris.
Good morning, Mr. Patterson.
It's nice to see you again virtually.
Yes.
And as at your deposition, I'm going to be asking you a few questions today. And this is Pete Patterson for the legislative defendants, for the record. In 2019, you defended a deposition in this case, correct?
Correct, I did.
And that was the deposition of Noah Reed, a member of the Alamance County Board of Elections, correct?
Yes.
And you defended that deposition because plaintiff's counsel did not have the bandwidth to have an attorney with every person who was being deposed, correct?
Yes.
So you were doing that as a favor to the plaintiff's counsel in this case, correct?
Yes.
And you have known counsel for the plaintiff's attorney, Allison Riggs, for many years, correct?
Yes.
You are not a political scientist, correct?
Correct.
And you're not an expert in the practices of any legislature other than the North Carolina General Assembly, correct?
Yes, that's correct.
You were not asked to opine whether SB 824 was passed with intentional racial discrimination, correct?
Correct.
Nothing in your report or testimony addresses that issue, correct?
Correct.
November 2018 was the first election in North Carolina history in which a party with supermajority in the General Assembly lost that supermajority, while the governorship was held by a member of the opposing party with veto authority, correct?
Yes.
The North Carolina General Assembly was therefore in an unprecedented situation following the November 2018 election, correct?
On that narrow circumstance, but the General Assembly had before been faced with power shifts. In 1994, the General Assembly lost the Democratic control of the House, and again in 2002. In both those elections, Republicans had a majority in the House, and in neither of those years did the General Assembly come back in lame duck session. So you're right as to loss of supermajority, but as to general loss of power, it's not the only time that's happened.
But you agree that this was the first time a party lost a supermajority while there was a governor with veto authority of the other party, correct?
Yes, that's what I said.
Okay. And although this had never happened before in North Carolina, you have not studied other legislatures facing similar circumstances, correct?
That's correct.
Okay, I would like to bring up JX31, which is your report and has been published already during this examination. If we could turn to paragraph 2, please. Okay. In paragraph 2, you state, I conclude that the legislative process that led to the enactment of SB 824 was aberrational compared to the general practices of the General Assembly, correct?
Yes.
And by aberrational, you mean either unprecedented or unusual, correct?
Yes.
You came to this definition of aberrational by your common understanding of the word, correct?
Yes.
You did not come to this definition through any scholarly study of the practices of legislatures, correct?
Correct.
By general practice, you mean a practice that is followed in the majority of the instances, correct?
At least in the majority. Yes.
You have not studied any scholarly literature on how legislative norms emerge and are established, correct?
Correct.
And when determining if a practice is a general practice, you cannot say how many times a practice has to be engaged in before it can be deemed the general practice, correct?
I use the general practice based on what has happened in the past.
Right, but you don't have any particular threshold for the number of times something needed to happen in the past before it becomes a general practice, correct?
Correct.
When you refer to norms, you are not referring to the formal rules of the General Assembly, correct?
Right. I am not referring to the House and Senate rules.
Okay, so you're referring to informal practices, correct?
I'm referring to consistent historical practice.
Okay, and so when you say general, if you say the General Assembly acted not in accord with general practices, you're not saying that the General Assembly acted in violation of legislative rulemaking requirements, correct?
Not right. It's not necessarily a violation of a House or Senate rule.
Okay. Let's go now to paragraph 37 of your report. Okay, the first sentence of that paragraph, you state, while a post-election lame duck session had been possible since 1983, it had never occurred before November 2018. But what you meant to say here is that in November 2018 was the first post-election reconvened regular session, correct?
Yes, yes, we went over that in our deposition. There had been possibly 3 extra sessions that were held as lame duck sessions.
Right. Before November 2018, there had been post-election lame duck sessions in 2002, 2004, and 2016. Is that correct?
Yes. Most of those were called by governor's proclamation.
Okay. And the governor of North Carolina did not obtain veto authority until 1996, correct?
Correct.
Of the prior post-election lame duck sessions, 2 in 2016 were called by joint legislative proclamation, correct?
Yes.
You have not considered the practices of other state legislatures in post-election lame duck sessions, correct?
Correct.
And you have not considered the practices of the U.S. Congress in post-election lame duck sessions, correct?
That's correct.
You have not studied any political science literature about lame duck sessions of legislatures, correct?
Correct.
Let's go to paragraph 52 of your report now. There you say, the November 2018 lame duck session is unique because it is the only reconvened regular session in North Carolina's history called in disregard of an authorizing resolution requiring adjournment sine die, correct?
Yes.
And you testified about this in your direct testimony, correct?
Yes, we just reviewed that.
Yes. And the sine die language comes from resolution 2017-12, which authorized the 2018 short session as a whole, correct?
Yes.
Resolution 2018-10, which was passed after resolution 2017-12, is the resolution that set a date certain for the General Assembly to reconvene the short session after the election, correct?
Yes.
And you agree that the General Assembly had the authority to amend resolution 2017-12 and any requirement that the 2018 short session be adjourned permanently, correct?
Certainly.
And in fact, arguably, the adoption of resolution 2018-10 implicitly repealed the requirement to adjourn the short session sine die, correct?
Yes, I stated that in my report because you have to make sense of what the General Assembly does when it does conflicting things.
Right, and there's no reason not to interpret resolution 2018-10 in this manner, correct?
Correct. What I'm saying was that they did it in disregard of that. I
Okay. Throughout the legislative process to enact SB 824, the only action you have identified that was even potentially inconsistent with a House or Senate rule in this is this issue with the adjournment of the 2018 short session, correct?
Well, when I reviewed the timeline for action, I mentioned that several House and Senate rules were suspended, but they were suspensions. So I guess I'm not quite sure what you're asking. There weren't, if you're asking were there rule violations, no, there were rule suspensions.
Okay, and so there were no rule violations in the enactment of SB 824, correct?
Right, not that I've identified.
The General Assembly did not in any way exceed its authority in enacting SB 824 in the way that it did, correct?
Right.
Okay. Let's go to paragraph 47 of your report. You testified about this as well, and you say the lame duck session that led to the enactment of SB 824 was an aberration because Resolution 2018-10 did not limit the topics to be considered during the session, correct?
Correct.
At the time the General Assembly adopted Resolution 2018-10, the General Assembly did not know whether the voter ID constitutional amendment would pass, correct?
Correct.
By adopting Resolution 2018-10, the General Assembly did not in any way limit itself to considering issues relating to voter ID, correct?
Correct. It didn't limit itself to any topic.
And there's no requirement in the North Carolina Constitution to limit the topics to be considered in a resolution reconvening a regular session, correct?
That's correct. What
And-
I was asked to review was whether what happened was consistent with the legislative practices, and it was not. It was certainly not unconstitutional.
And the constitutional requirement would be the only requirement that could have required the General Assembly to limit the topics to be considered in reconvening a regular session, correct?
Yes, they could limit them themselves, but if they didn't, there's no constraint.
Okay. The General Assembly has convened what is called an extra session by proclamation without limiting the topics to be considered in the past, correct?
No, that's not correct. Okay, what's confusing me was the word proclamation. When I think of proclamation, I think of the governor's proclamation, and you said General Assembly. So when the governor calls by proclamation, the Constitution requires that there be an explanation of the topics of the session. When the General Assembly calls themselves upon written request, then there is no constitutional requirement that they specify the topics to be considered. They have done so except in one instance, but there is no constitutional requirement.
Okay, so just to be clear, the General Assembly has in the past convened an extra session by request without limiting topics to be considered, correct?
Yes, they've done that once.
And that was in 2016, correct?
Yes, in my report in Exhibit 2 is the affidavit that Professor Joe Farrell made, and it at length describes all of the extra sessions and whether or not they had been limited. So if any want more information about that, you can look at that.
Okay, well, let's go look at that on page 70 of the PDF. Okay, is this the chart that you were just discussing?
Yes,
And this lists the extra sessions of the General Assembly since 1940, correct?
yes.
Okay, let's go down to the end of this chart on the next page. Okay, the first bullet says the three shaded sessions, 1981 number 1, 2016 number 2, 2016 number 4, are the only ones called upon request of 3/5 of the legislators. All others are called by the governor, correct?
Yes,
And these are the extra sessions by legislative request that we were just discussing. That's the type of session discussed
Yes.
in this bullet. Yeah, okay.
yes,
So this indicates that there have been 3 extra sessions called by legislative request between 1940 and 2016, correct?
yes,
And there was one in 1981, one in March 2016, and then another in December 2016, correct?
yes,
So it's your view that the one extra session that occurred in 2016 without setting limits was aberrational because those two prior sessions over a 35-year period did set limits. Is that accurate?
Yes. But I
So in this
also look at the context of the extra sessions called by proclamation. But yes, if 2 out of 3 set limits, then 2 out of 3 is the majority.
Okay. Okay, and the extra sessions by proclamation, just to be clear, are constitutionally required to set limits, correct?
Yes.
In your view, anything that happens for the first time is an aberration if it is inconsistent with what has happened before, correct?
I can't say yes to that in every instance, because it's an abstraction and I would like to have some context, but if it has never happened before, it would be an exception to the rule.
Okay, I would like to play a clip from your deposition. This is going to be at page 82, starting at line 10. And if we could play that clip, and then I'll happily show the transcript after.
Okay, so anything that happens for the first time is an aberration in your view?
And is inconsistent with what has happened before.
Okay, so
Okay.
Your Honors, I have an
And-
objection,
Okay.
if I may be heard.
Yes, ma'am, go ahead.
Thank you, Your Honors. We addressed this before, but I would ask that I would contend that that was not an improper use of impeachment, and that it needs to be established first whether the witness remembers testifying to this before, and that the testimony was inconsistent for this to be properly admitted as impeachment evidence. And I would respectfully ask the court for a direction to legislative defendants to follow that standard practice. Thank you.
The objection is overruled. Mr. Patterson, you may ask your next question.
Okay, and would you like me to publish the transcript of that exchange?
Yes, that would be fine. I think that's consistent with the rules that we've established for that.
Okay, great. So if you could, we could pull that up. Okay, Ms. Ferris, so do you recall giving that testimony or deposition?
Yes, I do. And I don't think it's inconsistent with what I just said. I thought what I just said was that if something happens that is different from what's happened before, it would be an exception to the rule.
Okay. Take that down now. Thank you. So under this understanding of an aberration, if there is another instance in which a party loses supermajority control in the General Assembly while the governorship is held by a member of the other party, it would be aberrational if the General Assembly did not reconvene an unlimited lame duck session post-election, correct?
No, well, if that's the question that was asked, then the question that I was asked were broader questions about legislative norms, about types of sessions, about what legislation typically, how it's typically considered, and not specific questions about lame duck sessions.
I understand, but what I'm asking you is based on your definition of an aberration, which I understand to be something that is inconsistent with what has happened before. It would be an aberration for a General Assembly that loses supermajority control while the governor has a veto to not come back in an unlimited lame duck session, correct?
No, because what you're saying is that they would have to come back every time, that because something happens one time, it has to happen every time. And that's not what I was saying.
Okay, let's turn to paragraph 3 of your report. Okay, and in that paragraph 3, you say, first, the session in which the General Assembly enacted SB 824 was, to my knowledge, the only regular session in North Carolina history that was reconvened. And then if we go to number 2, after an election for seats in legislative districts that had been newly drawn to replace existing districts determined to be racial gerrymanders, correct?
Yes,
The court decision finding that there were legislative districts in North Carolina that were racially gerrymandered did not affect the authority of the General Assembly to continue to exercise its power, correct?
correct.
In fact, the U.S. Supreme Court vacated a district court order purporting to shorten the terms of legislators elected from gerrymandered districts, correct?
Yes,
And the North Carolina Court of Appeals has rejected the proposition that HB 1092, which was the bill putting the voter ID amendment on the ballot, was invalid because it was enacted by the General Assembly after it had been found to include racially gerrymandered districts, correct?
yes.
Let's turn to paragraph 31 of your report. Okay, and there's a table there that says photo identification law and then primary sponsors, correct?
Yes,
The identities of primary sponsors are significant because they are the group of people that are the main proponents of a bill, correct?
yes,
But in your report, you do not include the primary sponsors of SB 824, correct?
right.
One of the primary sponsors of SB 824 was Democratic Senator Joel Ford, correct?
Yes,
But you chose not to list that in your report, correct?
correct. I was indicating what happened before that bill was introduced. Also,
Okay.
these had been House bills and the other was a Senate bill.
Okay. If we look at paragraph 32, you state there in the last sentence that House Bill 1092 passed in both the House and the Senate strictly along party lines, correct?
Yes,
SB 824 did not pass strictly along party lines, correct?
that's correct.
SB 824 was not a wholly partisan effort, correct?
Correct.
At the time that SB 824 was enacted, the Republicans could have passed voter ID legislation without any support from Democrats, correct?
Yes,
And
they
yet
had
the
super
general,
majorities.
okay. And yet the General Assembly crafted a voter ID bill that some Democrats supported, correct?
Yes,
You would agree that SB 824 was controversial when it was proposed, correct?
yes,
You have not studied the extent to which a party with supermajority control in the North Carolina General Assembly passes bills on controversial topics that obtain at least some support from the opposing party, correct?
that's correct.
You have also not studied the extent to which parties with supermajority control of legislatures outside of North Carolina pass bills on controversial topics that gain at least some support from the opposing party, correct?
Correct.
Okay, let's look at paragraph 35 of your opinion, which is right here in the second sentence. It says, in this reconvened regular session, Republicans passed Senate Bill 824, which included new implementing legislation for the voter ID constitutional amendment, correct?
Yes,
You do not mention the Democratic support for the bill in this paragraph, correct?
correct.
On second reading of SB 824 in the Senate, 3 Democrats voted in favor of the bill, correct?
Correct.
And that is the version of the bill that initially passed the Senate, correct?
Yes. I mentioned Republicans because they had enough votes to pass the bill.
Understood. And the 3 Democrats that voted for SB 824 in the Senate constituted over 20% of all the Democrats who voted on second reading in the Senate, correct?
Yes.
Democrats made motions to table SB 824, correct?
Yes.
It's not a general practice to try to table legislation, correct?
Correct.
So it was aberrational for some Democrats to try to table SB 824, correct?
It's unusual that motions to table bills are made. Most bills are not subject to tabling motions.
So under your definitions, the efforts to table SB 824 were aberrational, correct?
I wouldn't say the efforts to do that. I would say that it is unusual for a bill to be subject to a motion to table. Only controversial bills are generally subject to tabling motions. Few bills are receive tabling motions on the floor.
Okay, so then would you say that the fact that SB 824 received a tabling motion was aberrational?
It is, when the question is it usual for bills to be tabled, to try to be tabled? The answer is no.
Okay, and the only thing I'm trying to get a confirmation of is, under your understanding and definition, that means it's aberrational. Is that correct?
Well, I thought that you were trying to say that it was unusual for, maybe we're saying the same thing, that it was unusual for a Democrat to make a motion to table the bill. It was unusual for a tabling motion to be made for any bill.
Right, and all I'm asking you is that because it was unusual, under your definitions, that means it was aberrational. Is that right?
It was aberrational for the bill to be subject to a tabling motion.
Okay. You have not studied any scholarly literature relating to collaboration by legislators, correct?
That's correct.
All right, Your Honors, I would like to publish JX 773, which is one of the joint exhibits that has been admitted. This is the transcript from the third reading of SB 824 in the Senate.
All right.
And go to page 3, please. And where it says Senator McKissick, let's zoom in on that statement. And you see the statement here, Ms. Ferris, from Senator McKissick, correct?
I do see that.
And Senator McKissick is a Democratic senator, correct?
Yes.
And Senator McKissick voted against SB 824, correct?
Yes.
Okay, I'd like to read what Senator McKissick said. He said, "I'd just like to say thank you to Senator Daniel and Senator Kravic for their work on the bill and for being open and inclusive and listening to us on the other side of the aisle and trying to come up with something that is reasonable in terms of its approach. So I want to thank you for that effort. While I prefer the bill were it not necessary, we have a constitutional amendment, so it is. So I think it's the best that we try to move forward with it the best we can. Thank you. You did not consider this statement in drafting your report and assessing the degree of collaboration that went into SB 824, correct?
That's correct.
And you have no reason to doubt Senator McKissick's sincerity, correct?
Correct.
And you believe that this statement is relevant in considering the degree to which the process of enacting SB 824 was collaborative, correct?
Yes.
Legislators sometimes take action intended to undermine legislation, correct?
Yes.
For example, legislators will sometimes offer amendments called catfish amendments, which are designed to actually kill a bill instead of improve it, correct?
Yes.
The senators who introduced a motion to table SB 824 knew that the motion would fail, correct?
I don't know what they knew.
Okay. Your Honor, I would like to play a clip from the deposition. This is at page 98, starting at line 9.
All right.
The senators that introduced the motion to table SB 824 knew that motion would fail, correct?
Yes, they did know that.
Okay, and then we can bring up the transcript so that you can see that testimony in context.
You don't have to bring up the transcript unless you want to. I mean, yes, I mean, when you said no, then I thought, well, I don't know absolutely what was in their minds, but yes, I would certainly agree that the tabling motions rarely, if ever, succeed, and that if you make one, you can expect that it's not going to pass.
You cannot speak to the senator's motivation in proposing motions that they knew would fail, correct?
Correct.
Both the House and Senate adopted amendments to SB 824 when considering the bill, correct?
Yes.
And Democrats introduced a number of amendments that were adopted, correct?
Yes.
And again, the Republican supermajority could have enacted SB 824 without adopting a single amendment proposed by Democrats, correct?
Correct.
Okay, let's go now to page 18 of your report.
Well, by the same token, and along your way of thinking, if the Republicans had amendments that they wanted to adopt and they knew they had a Democratic supporter, they could have let that Democrat introduce those amendments so that there would have been Democratic amendments. So it's hard to tell from.
Okay. And on page 18, I'm sorry, not paragraph 18. Okay, and then there's a heading there, number 6, that says the enactment of SB 824 occurred at a rapid pace in an unprecedented session, correct?
Yes.
And then in paragraph 57, you say Senate Bill 824 is the only legislation implementing a constitutional amendment ever to be enacted in a post-election lame duck session, correct?
Yes.
The time constraints on the General Assembly in a post-election lame duck session are different than the time constraints faced by the General Assembly in other types of sessions, correct?
Yes, their terms ended on December 31st.
So the lame duck timeframe is necessarily compressed, correct?
Yes.
You did not compare the amount of time it took to pass SB 824 to the amount of time it has taken to pass other bills during lame duck sessions, correct?
Correct. And I will point out that most of the, well, except for this, the lame duck sessions have been extra sessions, which have been typically extremely short, devoted to one subject, and have rules that are adopted for rapid action because the subject is known in advance. There's been notice of advance, and it's pretty much predetermined what's going to happen. Those are explanations taken from Professor Farrell's report. But yes, given the number of days, the time is necessarily compressed.
You did not compare the speed with which the General Assembly enacted SB 824 to the speed which it has enacted other controversial bills, correct?
No, I didn't. Not all controversial bills.
Are you aware of any other bills that you would label as controversial that implemented constitutional amendments?
I can't think of one right now.
Okay. The General Assembly passed a number of other bills during the lame duck session besides SB 824, correct?
Correct.
Your testimony does not provide any basis to distinguish the General Assembly's purposes in passing SB 824 from its purposes in enacting any of the other bills that passed in the lame duck session, correct?
Correct.
Let's look at page 102 of the PDF of your report. Okay, and this is the table of proposed constitutional amendments that was discussed during your direct testimony, correct?
Yes.
Okay, let's go down to the entries for 2018. And let's blow those up if we could. Okay, and between 2017 and 2018, there were 6 amendments that the General Assembly proposed be put to the voters, correct?
Yes.
Your testimony does not provide any basis to distinguish the General Assembly's purposes in proposing the voter ID amendment from its purposes in proposing any of the other 5 amendments it put to the voters in 2017 and 18, correct?
I don't understand your question about the purpose, because the purpose was to put a constitutional amendment on the ballot. So I'm not sure what you're asking about distinguishing between the purpose of a constitutional amendment.
Well, if the purpose was to put a constitutional amendment on the ballot, then there's no distinction between HB 1092 and those other provisions, correct?
They were all enacted as proposed constitutional amendments.
Let me interject at this point. It's now 11 o'clock and it's time for our morning break. We're going to take about a 15-minute break at this point. We'll come back at 11:15. Thank you.